Assalamu alaikum wa rahmatullahi wa barakatuh, brothers and sisters. Today we'll discuss on the rights of option, which is called al khiyarat. So this is uh, the option is to cancel the contract. So as we know that we sometimes involve in contracts, we execute some contracts, but sometimes there are cases like fraud, or sometimes we change our mind, or sometimes it appears that the product is not what we have asked for, and especially for online transactions. So there are some Sharia principles, okay, and the Sharia allows to cancel the contract in certain circumstances. So what is this khiyarat? Okay, khiyar is the plural of khiyarat is the plural of khiyar, which means option. Okay, literally, a contractor has a right to ratify the contract or to annul within the period of option. So it is option is has a time limit. Okay, so the contractor, either the buyer or the seller or the lessor or lessee, they have an option. They have an option to cancel the contract within a period. Okay, so there are different types of options. The Hanafi scholars have mentioned 17 types of options. However, we are not going to discuss all these 17. We just discuss the major types of options, which are khiyarul majlis, option of the session, contracting session, khiyarul shart, option of condition, and khiyarul aib, option of defect, and khiyarul ru'ya, an option of inspection. So the first one is the khiyarul majlis, option of contracting session. Means a person has a option to cancel the contract in the majlisul akad, or in the session of the contract. So the definition given by the fuqaha is conferred. So khiyarul majlis is option of a contracting session is conferred to one, or conferred on each of the parties to a contract, allowing them to rescind it or not to proceed with concluding the contract, okay, usually of sale, before they leave the contract's assembly or session. So it means here actually a physical session where the buyer and seller, they get together and then they execute the ijab and qabul. So until they depart from that session, they have an option to cancel the contract. So let's say if the buyer and seller, they meet and they discuss and then they execute the contract with ijab and qabul. But after that, maybe after 10 minutes, while they are keep on discussing, okay, maybe the buyer changed his mind or the seller changed his mind, so they can cancel the contract. It is permitted based on the hadith in the Sharia. The hadith said the two parties to a sale have the option to rescind it, means to cancel it, as long as they have not parted, means as long as they departed, okay, and one of them may give the other the option for a longer period, okay, and then maybe one of the partner can give option to cancel the contract to other person, so that will be khiyarushat, that we'll discuss later. But here this hadith is a okay, is an evidence that a contracting parties, they can cancel, okay, the contract, they can rescind the contract as long as they are in the contracting session, as long as they do not depart. Okay. However, the scholars, they disagreed on whether there is such thing of called majlisul akad, what such thing called khiyarul majlis, whether we can cancel the contract. As we know that this option is actually against the objective of the contract, okay, because as we know, the objective of the contract is to bind. Once the ijab and qabul is done, then both of the contracting parties are binding. They are bound to follow what the contract requires. However, to cancel is just opposite to the objective. So however, as there is a hadith, so this hadith gives an exception, okay. So majority of the scholars from the Shafi'i and Hanbali, they said that this Khairul Majlis is valid and it ends with the depart of the parties physically or through mutual agreement. So majority of the scholars, including the Shafi'i and Hanbali, they allow it based on the previous hadith. Okay, that as long as they do not physically depart, it is valid. Okay. However, a minority group of the scholars, especially the Malikis and the Hanafis, they say a contract is binding immediately after ijab and qabul, offer and acceptance. Okay, so they said that the khiyarul majlis, the option to cancel until the end of the majlis is not valid. So they said that the above prophetic tradition means departing through speech. So the Hanafi especially, they do not allow, they do not consider the physical session. Okay, for them the hadith means actually something like a virtual session, or is depart through speech, means once they execute the ijab and qabul, and then maybe they start to talk something else, means the khiyarul majlis already ended. So that is according to the Hanafi. Okay, so now what is the weightiest opinion is that based on the hadith, okay, khiyarul majlis is valid because it is based on the maslahah. People can change their mind, and it is once someone is pronounced, and then maybe someone can pronounce the ijab and qabul mistakenly. So it is an option given by, and the hadith is a authentic hadith. Okay, however, I think the differences of opinion is actually about the session, the majlisul akad. Okay, so as you see now, we do online transactions. So this majlisul akad, or the session of the contract, should not be taken physically, only the physical session. But if we do online session also, if we are discussing through online, so as long as we do not depart maybe from our meeting, so that also can be considered as a majlis al-aqad. As long as we do not log out, for example, we should have the option to cancel the contract. So the principle of the Sharia is that it should be referred to the custom for its nature and characteristics. So if any online contract, okay, as long as, let's say, we do not log out, for example, it's considered maybe option to we can get the option to cancel the contract. So that's the khiyarul majlis. So it is valid again, but it depends on the custom to decide the duration of the majlis. Now, the second one is the khiyarushat. So khiyarushat is option of condition. So this is a type of khiyar, or option, that is actually given to the buyer or seller by themselves. Okay, means that when the buyer wants to buy something, he stipulates, okay, that I want to have a 3 days option to cancel the contract. It is not by the Sharia. Okay, so this is the definition, okay, through which, okay, so this is an option through which one party or both of them stipulate for themselves or for someone else the right to revoke the contract. Revoke is to cancel the contract within a determined period. So this is a option where the contracting parties themselves, they will stipulate during the contract. Okay, for example, the purchaser will say, okay, I purchased this item from you, but I have the right to return it within 3 days. Okay, so it is valid if the buyer stipulates it and the seller accepts it. Okay, and what is the legality of this khiyarushat? Is it allowed in the Sharia? Because it is also going against the objective of the contract. But the scholars, they refer to this hadith. Okay, one of the Sahaba whose name is Hibban ibn Munzir, he used to be cheated by the seller, so he complained to Rasulullah and sallallahu alaihi wasallam, and the Prophet sallallahu alaihi wasallam said, once you buy anything, you tell this, okay, no cheating, and I reserve option for 3 days. Means I will have the item for 3 days, and if I find anything, any cheating, I will cancel it. Mm. Imam Shafi and Ahmad, according to them, that the buyer or the seller have to stipulate during the period of the contract when they pronounce the ijab and qabul. At that point, they need to mention it. However, the others, they say it is allowed to stipulate until the end of the contracting session. So at the after they're executing the ijab and qabul, still the buyer and seller, they have option until the end of the session. So I would say this is the most preferred opinion, okay, because the Majlisul Akad, as we have learned, it is valid, okay. So the buyer and seller still have options to put any condition on the contract. Okay, now, so what should be the maximum period? Can it be just for 2 years? Okay, can I buy like I know a piece of cloth and I say okay, I will have option to return it for 6 months? Is it valid? No. Okay, this is not valid. Usually the scholars, okay, the majority, majority of the scholars from Hanbali, Imam Abu Yusuf and Muhammad, they say there's no restriction. Okay, but Hanafi and Shafi scholar, they say the 3 days, because Qiyas prohibits Qiyarushat, because based on our reasoning we can understand if the if this option is given for so long, the sellers, they will lose their businesses. Okay, and it's okay, it is against their maslahah. But according to the Malikis, depends on the case-to-case basis. Like 1 day for a piece of cloth, 1 month for a house. Okay, so this is their opinion. So, and I would say the Malikis opinion is the most is a preferred to me, because it depends on case-to-case basis. Because some of the items like house, for example, it takes some time to cancel. But for example, clothes, okay, it cannot be given a lot of time, okay, because of the risk associated with it. And then maybe for food stuff, it may not be given at all, maybe. Okay, so I would say the Maliki's opinion, the preferred, it depends on the case to case basis, but we can put 3 days like as a general standard. Okay, but it can be changed depend on the type of the asset. But Hanbali and opinion may not be accepted, because it goes against the public interest of the sellers. So now another important one is the khiyarul ru'ya, option of inspection, which is very important nowadays for online traders. Okay, so what is the khiyarul ru'ya? It is the right accorded to a person buying anything not yet present at the moment of the signature of the contract, to confirm or cancel the said contract after inspecting the object. So this is option, means somebody has bought something without seeing it, maybe by description. So once he sees it, sees one he can observe the commodity, he has the option to cancel it. Okay, so scholars, they disagreed on whether it is valid or not. According to Shafi'i, totally invalid, means according to him, this khiyarush ru'ya is not valid. Okay, because a contract in which the subject matter has not been examined is not valid. So according to Shafi'i, selling anything without showing to the buyer is not valid. Okay, so there is no question on the validity of Qiyarul Ru'ya. But Maliki and Hanbali scholar, they said it valid in some cases, because which cases, when examination of the okay, at the time of the contract becomes difficult or impossible. For example, if something in making, okay, or okay, something will be delivered later on, so and the asset may not be shown. Okay, sometimes some precious metal, for example, or sometimes some chemical items cannot be shown earlier. So the asset that cannot be shown to the seller earlier, so when there is a dorurah, okay, so at that point it is possible, they allow it. But according to the Hanafi scholars, they allow it. Okay, they are actually the the proponent of khiyarul ru'ya, the option of inspection, because according to them, it is allowed to sell something, okay, even though the thing is not present by it is allowed to sell only by description, okay. So the Hanafi scholars said the contract is enforceable but non-binding. So the contract will be executed, but it will be non-binding for the buyer. Okay, and again, it goes back to the hadith. Okay, do not sell what you do not possess. So the Shafi'i scholars, they do not allow khiyarul ru'ya, because they say that any sale, if a person sells something that he does not have, the contract is not valid. Okay, so the option also not valid. However, the Hanafi scholars argue that the hadith means that you should not sell something that you do not own and you are not able to deliver it. Okay, that we have discussed in the previous chapter. So if somebody does not own something, he does not possess a thing at this moment, but he is confident enough to deliver it on time, so he's allowed to sell it. So at that point, there will be khiyarul ru'ya, and we can learn from the hadith. There's Talha radiallahu anhu, one of the companion of the Prophet sallallahu alaihi wasallam. He was given the khiyarul ru'ya option against Uthman radiallahu ta'ala anhu. Talha radiallahu anhu, he bought a piece of land from Uthman, and then he was given an option. Once he will see that piece of land, then he got option whether accept or to cancel the contract. So based on that, okay, we can conclude that the khiyarul ru'ya is valid, and especially in this time of these online transactions, in order to protect the interest of the sellers, they should be given the option of sight. Okay, so however, there are some conditions. Okay, the first, the buyer must not have seen the good. If the buyer already seen it, the option already expired, and the property is non-fungible, means the it is a property that or a asset that is not available the similar in the market. But if the similar available in the market, so khiyarul ru'ya is not valid, because the buyer, he can actually can see the similar in the market. For example, let's say iPhone, let's say, okay, Apple iPhone. Okay, so there are many copies of it. So you can see in the video, and then you can go to any shop, and then you can see it. You have a knowledge of it. How? Okay, or any like a milk, or this that is fungible. So the khiyarul ru'ya does not apply, because we already have a general understanding of the asset or the commodity. And then what is the effect consequences if there is a option of khiyarul ru'ya? So the contract is will be executed, but it is non-binding. So the buyer can cancel the contract, but the seller cannot cancel the contract. It is it is irrevocable for the seller, but the buyer can cancel the contract. Okay. So khiyarul ru'ya, and then this is the most important khiyar option, option of defect, when we find defect in the commodity. So it is a right given to a purchaser in a sale to cancel the contract if he discovers that the object acquired has in it some defect, diminishing its value. So if there is a defect in the asset, and that defect diminishes the value of the asset will change. So then it will be khiyarul aib, and the scholars all agreed on the khiyarul aib. Okay, okay. Based on these two hadiths, first, the he who differs, another is not from us. Okay, man ghasha laisa minna, who cheats is not among us. And the second hadith, it is not permitted for seller to sell things which are defective unless he points it out to him. So it is not allowed for any seller to sell something which has defect unless he mentions to the buyer that, okay, this is my car, this is my handphone, there is something, there's some defect in it. If we do not mention it to the seller, to the buyer, then it will be haram, for it will be invalid for us as a seller to sell our item. So based on that, khiyarul aib is allowed. Okay. However, there are some conditions imposed by the scholars. First, it causes decrease in the subject matter, means the defect is such a big that the subject matter decrease. Maybe let's say it mentioned it is okay 5 inch long, for example, the handphone, but it is 4 inch long, for example, or 4.5. Okay, the defect was existed before the contract. Okay, and the defect is not like when the buyer receive it. Okay, is before the contract. Okay, the defect. But if the defect is caused by the buyer, of course there will be no khiyarul aib. Okay, the buyer should have no knowledge of the defect. Yeah, of course the buyer did not know before, but if he know, then there will be no option for him. The defect should continue after delivering till the time of the exercise of the option. Okay, sometimes there is a defect, but when we want to return it, at that time it gets okay. No, means the defect is still should persist. Is okay. It still should continue when we want to return the good. And then no agreement of non-guarantee. Okay, if there is a non-guarantee agreement, means that when we sign the contract, at that time the seller already stipulates that once you buy, you cannot cancel it. So if there is a such type of agreement or condition, then the Kiarul Aib is not applicable. Okay, so what will be happen when we can find a defect in the commodity? Okay, so the contract is revocable. Okay, we can revoke the contract, we can cancel it. Okay, the Maliki jurists, they say if the defect is minor, we got yasir, the buyer may confirm the sale while being returned part of the price. So we can also negotiate if it is a minor defect. So maybe we can negotiate with the seller to to get back some part of the price. Okay. Hambali jury said the buyer may confirm the sale if he is compensated regardless of major or minor defect. So according to them, either major or minor, if we negotiate and the buyer is compensated, so the contract they can proceed. But if the contract the assets is uh, perish, for example, totally, of course the contract will be invalid. So that's all. So khiyarul aib is very important, and also depends sometimes how much like defect is allowed in the sharia. Okay, it depends on case to case basis. Maybe the scholars they have some opinions, like for real estate, for example, maybe only 10% changes allowed, but maybe for clothes, maybe even a small defect is very important. So it depends on the size of the defect. It varies from case to case basis. So again, it is up to the buyer to cancel the contract. So that's all. So we have already discussed the different types of options. We have discussed the we have discussed the option of the session meeting, khiyarul majlis, and then we have discussed the option we have discussed the option of stipulation, khiyarul shart, khiyarul ru'ya, the option of inspection, and also we have discussed the option of defect, khiyarul aib. So these are the options which are the most important, and it shows that Islamic Sharia take care of the welfare of the buyer and also the seller, so that even though so that they are not cheated, and even though they have executed a contract, they can still think again, and they can cancel if there is defect or there are some changes in it. So with that, I thank you. Assalamu alaikum wa rahmatullahi wa barakatuh.